It'll be dismissed probably. Well, I guess I don't know what we're pleading to, so they're all initials. All right, thank you.
I need 2 seconds from Mr. Schmidt. He was only in jail 2 days. He doesn't remember how many days he spent before. On the 9th? In the 9th, out of the 10th?
Oh, well, 2 days is enough.
2 days, and he has 250 posted. You have a lot of cases. Oh, to do this case? Yeah. Okay. Somebody can just tell me how much he has posted, because it looks like he has 500 from March and then some more from. No.
This isn't just another routine day in court. This is a courtroom where second chances, past mistakes, and hard financial realities collide all at once. In today's session, we're following multiple defendants, each facing very different charges, but all standing at a critical crossroads. From a man with a long history of driving without a license finally getting a rare financial break, to another defendant facing serious burglary charges that could change his life for years, and a woman whose situation reveals the harsh intersection of poverty and the justice system. But here's the twist. Some of these outcomes depend not just on the law, but on choices made in real time, right in front of the judge. Stay with us, because what happens next might surprise you.
Right. Because I think 15 would have been done.
Yep. Permanent chair. Yeah.
I did not forfeit back in 2020. I thought it was going to come back. Yeah, that's what I'm seeing too. So, okay. So Amy may come, she's coming. I can go slow.
No, it's fine. We'll just do it.
We'll go on the record in the matters. 15 CT 67, 15 TR 997, 20 CT 47, 26 CT 14. State of Wisconsin versus Michael Glinky. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Glinky in person with his counsel, Eugene Harrington. We're set today in these matters for initial appearances. Mr. Harrington, the parties have reached an agreement. Can you please recite the agreement for the record?
Defendant will plead guilty to 26 CT 14, 15 CT 67, and 20 CT 47 to be dismissed
Outright?
outright,
Outright.
or read-ins.
Are they read-ins or outright?
Read-in.
Read-in. All right, so
Joint recommendation is costs, time served,
2 days.
2 days.
Okay, so with regards to 25 or 15 CT 67, 15 TR 997, and 20 CT 47, as well as 26 CT 14, he understands all of those charges and those maximum penalties,
Yes,
and he waives formal reading.
yes,
And at this time, not guilty pleas will be entered on his behalf. You would be entitled to a jury trial. You
Judge.
would be entitled to a speedy trial. What?
I think I interrupted you inappropriately. How's that?
I like that. Thank you. Accept that. So you would be entitled, but you're going to be entering a plea here today. And you're going to be entering a plea in 26 CT 14, which is 1 count of operating while revoked. Is that correct, Mr. Glinky?
Yes.
I have in front of me a plea questionnaire waiver of rights form all with other documents. Do you recognize those documents?
Yep.
Did your attorney go over those documents with you?
Yes.
Did he go over them essentially word for word?
Yes.
And you understand them completely?
Yes.
It looks like you have, yeah, you're 46, you have 11 years of schooling, you can read, write, you understand the English language, You understand those charges that or the charge that you're pleading to, as well as the maximum penalties, no mental illnesses or disorders, no alcohol, medications, or drugs, correct?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of the plea questionnaire. Do you understand those rights?
Yes.
Your attorney thoroughly went over them with you.
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
You understand that if you're not a citizen of the United States, your plea could result in your deportation.
Yes.
You understand that the state would have to prove on or around Friday, March 6, 2026 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you did operate a motor vehicle on a highway during such revocation period or thereafter. Do you understand what the state would have to prove?
Yes.
You understand the maximum possible penalty could be a fine of up to $2,500 or up to 1 year in the county jail or both.
Yes.
Do you understand that there is an agreement that's been reached between the parties that is that the court, a recommendation to the court for costs as well as for time served 2 days of jail? Do you understand I'm not bound to follow that?
Yes.
I said differently, I could sentence you to the maximum possible penalty. You understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney, and in particular that section called the probable cause section, where it basically says what happened that day and why you were charged with the crime?
Give us one moment.
Okay. Mr. Harrington is going to go over the criminal complaint one more time with
Went through
Mr.
the,
Glinky.
License plate. Why they pulled you over. You were driving, you admitted you didn't have a driver's license.
If it was anything,
Vehicle belonged to who?
oh, you don't, or I can maybe,
Just bought
So
it from
Amy's
Benjamin.
so I
oh, she's not.
can't do it.
Well, this is explanation. There aren't any drugs or alcohol or nothing in the car. You just driving without a driver's license. Any questions? Go ahead. Judge.
All right, so you understand the facts that are alleged?
Yes.
For the most part, are those facts accurate?
Yes.
Mr. Harrington, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Judge.
Has anyone made any threats or any promises to you for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand.
Yes.
And has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
And has he looked at this matter thoroughly?
Yes.
You're satisfied with his services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
All right, then as to the sole count operating after revocation in 26 CT14, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. The court will find you understand your constitutional rights and what it means to waive and give up your rights. We'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the sole count in the 26 case. The other matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
These are OARs that occurred over a long period of time where he'd get it and then he'd just leave. That's why we have cases spanning back like a decade. You have Kenneth Cutt. The first one's a Kenneth Cutt's case. I think the time he's spent in his brief arrests, as well as the jail he sat the 2 days of March 9th and 10th, I think that's sufficient punishment. Thank you.
Mr. Harrington.
Thank you, Judge. Gravity of the offense, when I look at the operating after revocation, preface my comments with every crime is serious. But in the grand scheme of our criminal code, this is right near the bottom of seriousness. But it is serious because the law requires that people if they're gonna operate a motor vehicle on the public thoroughfare, that they have a driver's license, that they be subject to the state. Mr. Glinky has never had a driver's license. When you look at the criminal complaints, the factual basis, he's never had a driver's license. He had a OWI conviction long ago. He tells me he has some fines that need to be paid before he can get a driver's license. But that he's slowly but surely working on them. He's employed by his family, and
Is this his mom?
yes, she's his driver today. And he makes money and he pays cash and for most of his bills, and he's just kind of getting through life on a pretty low level. This appears to be a change in that the crime is the same, but he showed up today, and that's to his credit. When I talked to him yesterday, and then I changed and rechanged the hearing date from yesterday to today, that confusion was caused by me, not by Michael by any stretch. But I think this is an appropriate disposition. I looked at CCAP. He doesn't have a significant criminal record on CCAP, but it is what it is. So I urge that the court follow the recommendation and impose the fine and give him some time to pay, and time served. Thank you, Judge.
Thank you. I usually don't do this, ma'am, but you did raise your hand, and I'm going to tell you, I have a question for you anyway. So what would you like me to know? Why did you raise your hand?
Because he's changing his life, from drugs and drinking and stuff. And he's raising actually an 8-year-old grandchild of mine. And he's doing the teachers. I'm constantly checking in, and the teachers say he's doing fabulous. The kid is clean. The kid is always taken care of.
Just which child? Your grandchild or this
The
kid?
grandchild, that's what
My
she means.
grandchild.
I know she
Okay.
means the grandchild, but for the record, that's great to know. The 8-year-old, yes.
So he's really making steps to.
I appreciate that, and I'm going to have one question for you, and I'm hoping you're going to answer in the positive, because that's going to go a long way to him improving and stepping a lot further faster. But I'm going to wait. First, I want to hear from Mr. Glinky, and then I'm going to ask you a question. I'm really hoping in the bottom of my deepest of all my hearts that you're going to be able to do what I'm asking. Mr. Glinky, anything you want to let me know, you want to tell me? Your mom said a lot, and that was all good and positive.
I'm not much of a talker, but
That's fine. That's totally fine. Here's the deal. I know a lot of fines and fees are from me, or not from me, but from my county, from here. I say me because this is me. And after today, there will be a total of $1,968 he owes. Here's what I'm willing to do. I'm willing to do this. I should have forfeited $500 a long time ago from 2020 when he failed to appear. But I'm going to tell you, I must have had a soft spot for him back then, because I'm like, no, I'm going to stay on whether or not I'm going to forfeit, because again, I must have had a soft spot for some reason. So I didn't forfeit that. I still can today, right now, if I wish to do that. So if I don't forfeit, I have his 500 bail now, and I have that extra 500 I should have forfeited. So that means that I have $1,000. If I'm able to get $225 today, I will waive the rest. And that's that's him getting his license a lot sooner. I need $225.
Yeah, I think I can do it.
You can do that today.
Yeah. I'll have to have money put into the account, but yes, I believe I can do that today.
Can you do it before you leave?
Yeah.
Okay, so if you can do that, then this is what I'm gonna do, because then Mr. Harrington, he'll be wiped out with me. Clean slate. So that means I'm not hindering his ability to get his license anymore. I don't know if he owes anywhere else, but at least with me, he'll be clean and free, all right? So what I'm gonna do is I'm only gonna assess the $200 DNA surcharge I'm required to do. I will waive the rest of the court costs and fees for today. I will take the 200 out of that. I will say the remaining 800 that I have in this case will be applied to past due fines and fees on the requirement that before you leave here today, you pay $225 to the clerk towards his fines and fees, and I will waive the rest. Deal?
No.
Deal. All right, done. So you should walk out of here with a clean slate. Don't drive in my county again without a driver's license, because I'm doing this for you. And it's for you, and it's for your 8-year-old. Okay?
Thank you.
20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. You're going to need to go to the jail and provide your DNA. This is something in which you can request the DNA be expunged through a written letter to the Department of Justice. If you fail to pay that $225 today, you're going to owe all of the money. I can issue a warrant and you could sit up to 6 months in jail. Okay. So
Okay.
hopefully we're going to have everything resolved and everything taken care of before you leave this building. It'll be paid, then you go to the jail, you provide your DNA. We're all good to go. Mr. Schmidt,
Nothing from me.
Mr. Harrington.
Thank you, Judge.
All right, then we are adjourned.
Tell the judge louder. Thank you.
Thank you, Judge.
If you go to the clerk, they'll give you the DNA form. We're out of toner.
I'm glad to hear that you're doing all of these positive things, okay? Because I'm going to tell you, walking in here, I was going to take that $500 from back in 2020. But I heard great things. Don't let me down. Okay, I'm proud of you. I don't know if I have anyone on. So Miss Dimmond is right here. Why is she not on my calendar? Is she not on my calendar?
She's on mine.
2:15, we said it
Oh,
yesterday.
it's on the first page. Sorry, we hopped over to Glinky. All right. We will go on the record in the matters 26 CF 34, 26 FO 104, State of Wisconsin versus Darcy Dimmond. The state appears through District Attorney Kevin Schmidt in person. We have Eugene Harrington, Defense Counsel, in person. Ms. Dimmond appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a plea and sentencing hearing. Ms. Dimmond, you're appearing by video conferencing. Your attorney informed the court off the record that he has went over all of the plea questionnaire and all of the documents and information with you. Is that correct?
Yes, he has.
And you're appearing by video. Are you okay with appearing by video?
I am.
Okay, if you have any questions or any concerns and you need to speak with your attorney, just let me know and I will send him into the Zoom room and put you in a confidential breakout session, okay?
All right, thank you.
All right, so Mr. Harrington, the parties have reached an agreement. Can you please recite it for the record?
Count 1 to be dismissed. Count 2, she'll plead to count 2, paraphernalia. Count 3 is an FO. She'll plead to that. The agreement is time served, cost, DNA, and surcharges. Standard fine for count 3. She's been in jail since March 22nd. She's also on a hold. I think her hold expires 20th of April. Is that correct, Darcy?
Yes, yes,
All right, so there will be some type of punishment for this matter.
Yes.
Okay, so that's the agreement you've reached, Ms. Dimmond?
yes, it is.
And it looks like from what I can see on the video, you have a copy of the plea questionnaire waiver of rights form in front of you. Is that correct?
I do.
And so your attorney thoroughly went over that document with you
He did.
and he read it to you essentially word for word?
Yes, he did.
And it's all correct information on that document?
It is. I've looked it over.
Okay, and so on that document, it goes over your constitutional rights. Did he thoroughly go over those rights with you?
Yes, he did.
And you understand them completely?
I do.
Do you need me to go over those rights with you in any more detail?
No, I understand them.
All right, and so you understand that by pleading guilty, you're waiving and giving up those rights?
I do.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes,
All right, and so do you also understand that Here, the state would have to prove on or around March 22nd, 2026 in Burnett County, Wisconsin, you knowingly possessed with the primary intent to use a glass bubble pipe to inhale a controlled substance. Do you understand what the state would have to prove?
I do.
Do you understand the maximum possible penalty could be a fine of up to $500 or up to 30 days in jail or both?
Yes, I do.
Do you also understand that the state would have to prove for count 3, the trespass, the same date, time, and place that you entered on any land of another after having been notified by the owner or occupant not to enter, and you remained on the premises contrary to Wisconsin law?
Yes, I do.
Do you understand the maximum penalty for that Class B forfeiture would not exceed $1,000?
I understand.
All right. And do you understand that the parties have reached an agreement for time served and costs? But do you understand I'm not bound to follow that recommendation, and I could sentence you to the maximum penalties?
I do understand that.
And you still wish to proceed and enter guilty pleas?
I do, ma'am.
Did you go over the facts alleged in that criminal complaint with your attorney where it basically says what happened that day and why you were charged with the crimes?
I do.
For the
did
most
understand.
part, are those facts accurate?
They were.
Mr. Harrington, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Judge.
Has anyone made any threats or any promises to you for you to plead guilty to these 2 charges?
No, they have not.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
I am.
and voluntarily?
Yes, ma'am.
Has your attorney represented you competently
Yes, he has.
and he's answered all of your questions?
He has.
Are you satisfied with his services?
I am. Thank you.
Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
And as to count 2, possession of drug paraphernalia, how do you wish to plead?
I'm pleading guilty.
As to count 3, trespass to land, how do you wish to plead?
I'm pleading guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of those 2 charges. Count 1 will be dismissed, as well as the other forfeiture matter. A judgment of conviction will be entered. Argument, Mr. Schmidt.
She sat 18 days in jail, not counting today, since she was arrested and the 250 cash bond was imposed. So for paraphernalia, she's already gotten a pretty high sentence for that offense. I think that's sufficient in this case. Thank you.
All right, Mr. Harrington.
Again, Judge, this is a relatively minor offense, although every crime is serious, certainly, because it violates the norms and rules of society. This is a 57-year-old lady living in a car. Served 18 days in jail. I would submit that the proposal is appropriate given the circumstances and the defendant's background. Thank you, Judge.
All right, thank you. Ms. Dimmond, is there anything you want to tell me, you want me to know?
I'm just sorry for wasting the court's time and for being where I should not have been.
I appreciate that. This is a low level offense. Drug paraphernalia, I think it was even a broken pipe or something of that nature. And trespass to land, you knew you shouldn't go there. You knew you didn't need to snoop around in that property. I believe this was the property that burned to the ground and we had fatalities. You shouldn't have been there. You shouldn't have been snooping or doing those things, but it's not a high level offense. So I'm going to follow the recommendation as it relates to the drug paraphernalia. I'm only going to assess $200 DNA surcharge. As to the forfeiture, I'm only going to assess $114.50. I'm going to waive all other court costs and fees. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I am going to order that at minimum $25 a month be paid towards your fines and fees. That will begin, I'll give you until June to make your first payment. If you fail
you.
to make you're welcome. If you fail to make your payment though, and you don't give me notice that something's going on and why you can't pay it, I will issue a warrant and you could sit up to 6 months in jail. Very important you communicate with me, okay?
Yes, ma'am.
So I have an address of Lee Street in Osceola. Is that an address where you can get mail?
Yeah, that is my son's address. That's where if anything ever should go wrong or I end up with a warrant, they end up letting him know and then I end up turning myself in because I do not like bothering my son. But yes, it
I'm
is a
glad to
place that
hear
can be
that.
found.
It's your safe place, so that's
It
good.
is. It is.
Do you have a telephone number or can we get a number for your son just in case we need a call with regards to
I do.
before
My
we issue a
son,
warrant?
my son pays for my phone bill as well. So, but I can give you his number too because he's got me right on location. He knows right where I am at all times.
All right, give me your number first.
Okay, my number is 612-461-9168.
And your son's?
And my son's name is Derek, Derek, same last name as mine.
Okay,
Is 612-461-9144 is his number.
excellent. Thank you so much. May we send you text messages and him text messages if we need to?
Yes, ma'am. Yes, ma'am.
All right, thank you so much. You have 20
Thank
days
you.
to appeal. If you fail to pay, I said I would issue a warrant, so you got to communicate with me. The court could enter a civil judgment against you as well. I do need your DNA. The jail will make sure that we get that. You would have the ability to request it be expunged through a written letter to the Department of Justice, not to me, the Department of Justice. It's easy to do. Good luck to you, Ms. Dimmond.
Thank you.
And I'm going to
Thank you.
order 18 days of jail, time served, along with the fines and fees.
I appreciate
We
it,
are
Your Honor. Thank
adjourned.
you much.
Dismiss count one.
I dismissed them all. Yep, count one and the other forfeiture.
All right, thank you.
All right, thank you. We're adjourned.
Thank you.
Read the one, time served on that. He has jail credit from March 9th to March 24th.
Mr. Ripple and jail, can you hear me, Mr. Staples?
Okay, I'll get out of here. He's supposed to be here at 2:00. Thanks.
The jail, I cannot hear or see you. Yes, can you hear me, Mr. Staples?
Yes, ma'am.
We will go on the record in the matter 24 CF 69, State of Wisconsin versus Joshua Staples. The state appears through District Attorney Kevin Schmidt in person. We have Stephen Ripple, Defense Counsel by video conferencing. We have Joshua Staples by video conferencing in custody in Burnett County Jail. We're set here today in this matter for a plea hearing. Mr. Staples, you and your attorney are both appearing by video conferencing. You would have the right to say, you know what, Judge, I want both my attorney and myself to be there in person. Do you understand that, right?
Yes.
And you are both appearing by video conferencing. At the last hearing, I believe you indicated that you are okay with Mr. Ripple appearing by video conferencing as well as yourself. Is that correct?
Yes, Your Honor.
If you have any questions or any concerns and you need to speak with your attorney, let me know and I will send you into a confidential breakout session, okay?
Okay.
All right. Mr. Ripple, can you please recite the agreement for the record?
With a plea to the sole count of burglary as charged, the state will dismiss and read in all other charges. We will stipulate to restitution of $1,000 to the victim, costs, pre-sentence investigation. The state will cap at the pre-sentence investigation and the defense is free to argue.
All right. And that is the agreement that you've reached, Mr. Staples?
Yes, Your Honor.
We are in victims' rights compliance?
Yes, Your Honor.
All right. Okay, I have in front of me a plea questionnaire waiver of rights form. It looks like both you and your attorney signed that document. Did you do so, Mr. Staples?
Yes. Yes, Your Honor.
Did your attorney thoroughly go over that document with you,
Yes, he did.
essentially word for word,
Yes, ma'am.
and you understood everything completely?
Yes, I do.
You're pleading guilty to one count of burglary. You're 44 years old. You have 11 years of schooling. You can read, write, you understand the English language, and that's all correct.
Yes, correct.
Attached to the plea questionnaire, there are jury instructions with the burglary with intent to steal, as well as the agreement that's been stated on the record. Did your attorney thoroughly go over with you what the state must prove to prove your guilt beyond a reasonable doubt?
Yes, he did.
Did your attorney go over with you the maximum possible penalties you face?
Yes,
You do not have a mental illness or disorder and no drugs, alcohol, or other medications in the last 24 hours, correct?
correct.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that document. Did your attorney thoroughly go over those rights with you?
Yes,
Do you understand them completely?
yes, ma'am.
You understand that by pleading guilty, you're waiving and giving up those rights?
Yes,
Do you need me to go over those rights with you in any more detail?
no, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes,
Do you understand that there is an agreement that's been reached here between the parties that the court will order what's called a pre-sentence investigation report, and the state is capped at that recommendation? Do you understand what a pre-sentence investigation report is?
yes, Your Honor.
Do you need me to go over what that document is to you in any more detail?
No,
You understand that as part of that document, the Department of Corrections will be providing a recommendation to the court as it relates to sentencing.
yes,
You understand I'm not bound to follow that recommendation.
yes,
You understand I'm not bound to follow the recommendation of the state or the recommendation of defense. You understand that?
yes,
Do you still wish to proceed and move forward and enter a guilty plea?
yes, ma'am.
You understand that if I believe, based upon the facts of the case and information in that document, as well as arguments by each side, that I could sentence you to the maximum possible penalty?
Yes,
Did you go over the criminal complaint with your attorney?
yes,
In particular, there is that section, it's called the probable cause section, where it basically says what happened and why you were charged with the crimes. Do you remember that?
yes,
For the most part, are those facts accurate?
yes, ma'am.
The state would have to prove here, as it relates to the burglary, that on or around November 30th, 2023, in Burnett County, Wisconsin, you intentionally entered a building, the Yellow Lake Lodge, without consent of the person in lawful possession of that place, with intent to steal items of value. Do you understand what the state would have to prove?
Yes,
You understand the maximum possible penalty could be a fine of up to $25,000 or imprisonment of not more than 12 and a half years, or both.
yes,
Are you admitting here today that you in fact did engage in a burglary?
yes, I am.
And you did have the intent to not only enter that building, but to steal items of value?
Yes,
Are you pleading guilty because you are guilty?
yes, Your Honor, I am guilty.
Mr. Ripple, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes.
Has anyone made any threats or any promises to you, Mr. Staples, for you to plead guilty to the charge?
No, ma'am.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing
Yes, I am.
and voluntarily.
Yes,
Has your attorney represented you competently?
yeah, he's great.
He's answered all of your questions
Yes, ma'am.
and he's looked at this matter thoroughly.
Yes,
Has he looked at all of the discovery and the evidence and discussed that with you?
yes, he did.
Has he discussed with you a potential for any legal defenses or a lack of defenses?
No, ma'am.
Did he say, if we go to trial, you could possibly have this defense?
Oh, yes, yes, Your Honor,
Okay, and he went over, well, I'm looking at the facts here and based upon the facts, I'm not seeing any defenses.
Correct.
And so he discussed with you that it is your right to go to a jury trial?
Yes.
And are you satisfied with the services?
Yes, ma'am.
Any questions for the court or for your attorney before I proceed?
Just to my attorney about what we talked about over the phone, about the payment. Should I say anything about that, or should I just leave that up to him?
No, I have answers for you, and we can talk about that in private.
Okay.
Yep, and then that'll all come at sentencing time with regards to the payment, or I guess your attorney can let me know here today with the plea, whatever is easier or you want to do. But so no other questions, Mr. Staples?
No, Your Honor.
Then as to count 1, burglary of a building or a dwelling, a class F felony, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. It will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be, and count 2 and 3 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. I'm going to order a pre-sentence investigation report. Long form, agent does not need to appear, but should be readily available by telephone. Any bail bond is now revoked. Let's get a date and time for sentencing. I could do, and are you going to be traveling and being here in person, or is Mr. Staples okay with you both appearing by video?
He's okay with by video. If it's possible to travel, I will, but
And he nodded his head up and down that he is okay with video. Is that correct, Mr. Staples?
Yes. Yes, Your Honor.
Are we going to have any victims making a statement?
I'm not for sure.
Okay. I can do June 17th at 1.
that works.
Set it for an hour, please. All right, June 17th at 1. We will see you then. Video is approved. Thank you. We are
Thank you, Your
adjourned.
Honor.
Thank you, Judge.
Thank you. All right. 2:15, I guess, is our next one.
Today's courtroom session highlights just how complex and nuanced the justice system can be. We saw one defendant receive a rare opportunity to wipe out significant financial penalties in exchange for immediate accountability. Another faced the consequences of low-level offenses shaped by difficult life circumstances. And a third step into a much more serious legal battle with a felony burglary charge and a pending sentencing investigation. Across all these cases, one theme stands out: the balance between punishment and opportunity. Judges aren't just enforcing the law, they're constantly weighing fairness, risk, and the potential for rehabilitation. If you found this case as thought-provoking as we did, make sure to hit that like button. Share your thoughts in the comments, especially on whether these outcomes felt fair. And don't forget to subscribe for more in-depth courtroom breakdowns you won't find anywhere else.